Don't copy famous trademarks. I've said this before, and today I have a case study that illustrates this point. I'm going to spend the next 5 minutes talking about this. I'm Angela Langlotz, trademark and copyright attorney. I go live here on weekdays to talk trademarks and copyrights. If you have trademark or copyright law questions, drop them into the comments below. I'll answer them on a future live, and don't forget to like and subscribe to get all my newest material. So yesterday, somebody called me to give an expert opinion about a trademark kerfuffle involving a Dallas clothing company and the city of Dallas. So it seems that Dallas has a famous trademark, that concentric triple D with a little leafy thing in the middle. I'm going to show you it in a minute. And the Dallas Clothing Company has appropriated basically that exact same mark, except it has a star in the middle and not the leafy tree. Why is this a problem? Well, Famous Trademarks and Dallas's trademark, in use since 1972, is arguably famous for the city of Dallas. So this clothing company, also based in Dallas, has decided to use the famous Dallas trademark for their own purposes, thus sort of implying a false association between their company and Dallas, as if there was some official relationship. And the other issue is this issue of dilution. I'm going to talk about both of those things, but first, let's look at the marks. So here we have the famous Dallas trademark, and this has been in use, you'll notice, since 1972, but they just last year in August of 2020 applied to register it. So this is a situation that comes up a lot. People will use trademarks but not register them. This is always a mistake. Why? Because it allows the naughty infringer who has this trademark to come in and get a registration. I'll page down a little bit so you can see it. So you can see it's essentially the exact same trademark with a star in the middle rather than the leafy tree looking thing. They started using this mark in 2007, more than 40 years after Dallas started using theirs. And then they applied to register it in 2012 and got their registration in 2014. But you can see the resemblance between these two trademarks. They're almost exactly identical. Now, the goods and services are different. So this mark is for clothing, athletic apparel, right? Shirts, pants, jackets, footwear, hats, caps, athletic uniforms. And then the Dallas mark is for a bunch of different services: wastewater treatment services, recycling, emergency medical, municipal services, financial assistance, and promoting business and tourism in Dallas. So if the goods are so different, why is this still a trademark infringement? Well, Dallas, like I said earlier, has been using this trademark since 1972, almost 50 years. So they can make the argument, and I think it's a winning one, that the mark is famous for its association with the municipality of Dallas, with the city of Dallas. So for somebody else to come along and use the mark for clothing does two things. It dilutes the Dallas trademark, the city of Dallas trademark, because now Dallas can't license their own trademark for use with clothing. What if Dallas wanted to start a clothing line to raise money for the city? Well, now they can't because this infringer has a confusingly similar mark for clothing. The second issue, so there's a dilution issue. Dilution is when a famous mark is used for goods and services that are not covered by their original trademark, but because the mark is famous, they get protection from dilution, which is the use of the mark on anything else, because famous marks tend to have brand deals with other companies and expand their use rather widely because they're famous. And this dilution effectively prevents them from doing that. So that's one problem. The second problem is that, again, as I mentioned, the infringer is implying some relationship with the city of Dallas through their use of a similar mark. This is very problematic because now Dallas might They might object to some of the decorations or the advertising that the clothing owner is using. They don't have any control over that, yet there seems to be a relationship because the logos are so similar. So that's the problem. So the moral of the story is, if you have a trademark, register it. And moral number 2, stay away from famous trademarks. You will likely get sued, and you may even have your trademark, you'll probably have your trademark canceled, and you may get sued, all right? Both of those are very expensive adventures. Plan to spend tens of thousands of dollars on each. So I recommend always to my clients, stay completely away from famous trademarks. I'm Angela Langlotz. Find me online at TrademarkDoctor.net. I'm also on YouTube at video.TrademarkDoctor.net/YouTube. You can find me on Facebook. I'm there at facebook.com, Trademark Doctor, and I'm on TikTok at Trademark Doctor.